When we speak of right to property, the first thing that comes to our mind is that it is no longer a fundamental right. Hello everyone, welcome back to my channel. In this video, we are going to talk about Article 31, that is right to property, and what is the status of right to property in the present time. Right to property was talked about in two different articles, that is Article 19 Clause 1F and Article 31. Article 19 Clause 1F guaranteed to the Indian citizens a right to acquire, hold and dispose of property. And Article 31 used to say that no person shall be deprived of his property except by authority of law. Means Article 19 Clause 1F was giving right to property to citizens of India, and Article 31 was giving right to property to both citizens and non-citizens. However, being one of the most controversial rights, right to property was abolished as a fundamental right and made it a legal right under Article 300A in Part 12 of the Indian Constitution by 44th Amendment Act of 1978. Article 31 was amended several times, like in 1st, 4th, 7th, 25th, 39th and 42nd Amendment. By 1st Amendment Act of 1951, two clauses were added in Article 31, that is Article 31 Clause A and Article 31 Clause B. And by 25th Amendment Act of 1971, Article 31 Clause C was added in the Indian Constitution. Now let's understand the story from the beginning. That is why and when these amendments were made to the Indian Constitution. Right to property was implemented since our Constitution came into force, that is 26 January 1950. At that time, the government felt that right to property should be a fundamental right. When India got independence from British rule, then the condition of the country was not good and it needed a lot of development, like factories, industries, railway tracks, roads, dams, institutions and a lot of social development. And for all those developments to proceed, the government needed land. For example, when government had to build railway tracks, someone's property used to come in the way, for which they were not ready to give. Apart from this, very large area of lands were with those people who used to be zamindars during British rule and had already taken a lot of land before independence. One of the objectives of the government was to take some of the lands which was with the rich people of that time and give it to the poor farmers to maintain social equality. So what happened, whenever the government talked about acquiring land and property, people directly approached the Supreme Court saying that their fundamental right is violating. So basically no one was ready to give up their property. Since right to property came under fundamental rights, the government was unable to do anything. As we all know that no fundamental right can be violated by government or any other private individual. All these things were happening during the year 1950. Our constitution came into force on 26 January 1950. And almost a year after, in 1951, the very first amendment of the constitution was done. This amendment was done during the tenure of Prime Minister Jawaharlal Nehru. During that amendment, many changes were made in the constitution, one of which was Article 31, that is right to property, due to which the government was facing so many problems in acquiring the property for development. So what was amended in Article 31 by the First Amendment? Through the First Amendment Act of 1951, two clauses were added to Article 31, that is Article 31 Clause A and Article 31 Clause B. Let's see what was said in those two clauses. In Article 31A, it was said that if the government makes any law in these 5 following categories to acquire any property, the government can do so. And by doing so, even if there is a violation of fundamental rights mentioned in Article 14 and 19 of Indian Constitution, it cannot be challenged in the Supreme Court under Article 32. In simple words, Article 31 Clause A was immune to Article 14 and 19 of Indian Constitution. Article 14 for right to equality and Article 19 for right to freedom. Now let's see what things have been mentioned in these 5 categories. In the first category, it is said that the acquisition by the state of any estate or of any rights therein, or the extinguishment or modification of any such rights. The general meaning of state is a large area of land in the countryside that is owned by one person or family. As you all know that when our country became independent, there were many poor people in the country. And the few people who were rich had a lot of land for agriculture purpose. So the main objective of the government was that some land should be given from the rich people to the poor people so that equality is maintained, which is one of the objectives of our preamble. And the same thing was said in the first category of Article 31 Clause A, that if the government wants, it can acquire such land under the law and can also modify or completely abolish such rights. And even if there is a violation of Article 14 and 19 by doing so, then it will not be challenged in the Supreme Court. That is, it will not be considered as violation of fundamental right. Now let's come to the second category, that is B. It says the taking over of the management of any property by the state for a limited period either in the public interest or in order to secure the proper management of the property. First of all, you should think that when our country got independence, then what would have been the situation at that time? If someone had a property where people used to work, imagine what kind of management would have been at that time. People would have been forced to work by paying less money. Their health would not have been taken care of. They would have been made to work more than necessary. So, to remove these things, this category was added, under which it was said that if the government wants, it can take over management of such property to use them for enhanced growth. However, this could be done for a fixed amount of time. Let's move on to the next category, in which it is said that the amalgamation of two or more corporations either in the public interest or in order to secure proper management of any of the corporations. Amalgamation means merger of two or more companies. It simply meant that the government could combine two or more corporations like factories or industries into a single unit if they wanted, either for the public interest or for better and proper management of the corporation. As you must have seen recently that government has merged some of the banks into a single bank. So the government can do such kind of merging. Coming to the fourth category, in which it was said that the extinguishment or modification of any rights of managing agents, secretaries and treasurers, managing directors, directors or managers of corporations, or of any voting rights of shareholders thereof. After introducing this section in Article 31, the government got the power to modify or completely abolish the rights of the managing directors, agents, secretaries, treasurers, managers of corporations, or any voting rights of shareholders of the companies. What happened by doing so that companies' executives and officials who used to force their workers to work on low salaries and took the wrong advantage of their rights, they got scared of the government, against which they couldn't even go to the Supreme Court. Now coming to the last section of Article 31 Clause A, in which it was talked about extinguishment or modification of any right of mining lease or license. Why this section needed to be introduced in Article 31 Clause A? This was done because there were some people who had got mining rights before independence and they had license. So when the government started taking those mining areas, their owners went straight to the Supreme Court. Therefore, while introducing this section, the government said that we can change or completely abolish your mining rights or can also cancel your mining license for the public interest. These were the 5 important points of Article 31 Clause A, which was added to the Article 31 by the First Amendment Act of 1951. As we understood that if the government makes any law within these 5 categories, and because of that the fundamental rights mentioned in Article 14 and 19 is violated, even then it cannot be challenged in the Supreme Court. One more important point to be noted, that if the government is acquiring any property, then it can acquire in 2 conditions. Number 1, that acquisitions should be for public interest, and number 2, the owner is getting proper compensation for the property that has been acquired. So in this video we have understood Article 31 Clause A. In the next video we will understand both Article 31 Clause B and Article 31 Clause C.